Now I can see them. All right, during the break, I consulted with court staff. They are unable to print the chat out. So what I'm going to do with the motion for sanctions is Packard, or Lori, I will grant you a continuance on that motion. We're not gonna have another hearing unless what you file is completely startling on that issue. But I'm going to give you, is 14 days enough, Ms. Packard and Lori, to file anything else you'd like to file on the motion for sanctions? Okay, you're asking for 3 weeks? You could have 21 days, okay? And then we'll give Ms. McCann, how much time do you need to respond to anything that Lori might file?
2 weeks, Your Honor, because now we're getting into the holidays.
Okay, so 2 weeks. The court has all of your documents. Ms. Packard, at this point, I think asking you to file affidavits is probably pointless. So if you're going to file anything else, please make specific reference to the reasons or the documents you're filing. File things individually, not in a mass group. And I've got one motion that you filed that had 6 or 7 different motions included in one document, which does not, we can't figure out how to respond to any of that in Odyssey. So the court is going to issue an order today with respect to the real estate, as we discussed.
Do you mean the metal scrap or the delay in a decision on sale of real estate?
We're going to issue a decision on the sale of real estate that basically says you have up to 90 days to file the inventory.
The interim account.
The interim account,
Okay.
and then have a further hearing on that motion.
Okay.
I will, if you submit a proposed license to sell regarding the scrap metal, I will go ahead and sign that. And with respect to the motions for sanctions, if Ms. DURKEE wants to update them in any way, I'll give her up to 21 days to do so, given her permission. If she doesn't think she wants to update anything, that's fine. She could just send a note saying, I don't need to update anything. I have your response to her motions. I have Ms. DURKEE's motions. At this point, I'm trying to get the case to move along, not waste more time, and that's why I'm saying to Lori that I don't need affidavits, and I don't need more filings. I just got a note that they scanned in 2 emails that you sent, Lori. Is that things you sent today?
I think she said she sent a copy of emails with Justin Ray McCann accusing me of stealing. That's not a statement to the court. It's not a signed pleading before the court. an email between an attorney and client can be used under Rule 11 to show improper conduct of another attorney is not involved in their discussions or filing actual pleadings, in this case, making accusations. This is a paper-driven rule. Rule 11 has to be shown as intention to mislead, misdirect the court, or actually make false statements to the court.
I'm not seeing anything in the email. I'm just looking at the email that was filed, sent to the court today at 2:01 p.m. And it was something from the hearing, after the hearing on January 25th. Let me just go back and look at my notes. I have fairly lengthy notes from that day. Oh, at the very bottom of that note, I wrote, not an ongoing issue, accusation that LP is a thief. I declined to issue any orders. That means I didn't take it as being something that was either important or was made any sense under the circumstances. I cannot tell from my notes who allegedly said that, whether that was
Mrs. Packard.
or Ms.
Ms.
or
McCann?
whether that was Wendy.
No, it's Ms. Packard who made a claim that I had said something to her attorney.
Mm-mm.
Again, Rule 11 is about written statements and pleadings made to the court. If she can show that I wrote something to the court or made a statement in writing and signed it and submitted it to the court, fine. But that's all Rule 11 covers, Your Honor. I want to make it very clear. We're talking about evidence of intention in writing, signed, and filed with the court. That's my understanding of what Rule 11 covers.
Well, I believe that's correct with respect to Rule 11, although there is a requirement of candor towards the tribunal. In any event, I don't recall you making an in-court statement accusing Ms. Packard of stealing. Ms. Packard could have said that there was something done outside of the courtroom that she was denying, and that may be very why I said, I'm not doing anything with this, because it did not seem to be anything that I would take seriously, either that Ms. Packard would go and steal things from the estate, that didn't make any sense to me, or that, Ms. McCann would have said something, or even that Wendy would have said something like that. So I'm almost suspecting, thinking back to my notes, that Ms. Packard was reporting that something was said in a different setting, accusing her, and I didn't find it helpful.
Right. Your Honor, in addition, I have no court order instructing me to get an appraisal of the equipment in question. And the the Herchak desktop valuation is not listed or titled as per her statement as an appraisal. It's actually titled as a desktop opinion, and that's all we submitted it as. It's listed as Exhibit 21. I think the confusion happens because we cited Mr. Herchak and the town of Shoreham's addresses under appraisers because they are the source of the financial values.
Right,
and
and that's,
not appraisers, and that's not, in no way was I instructed to go and get an appraisal. We talked about an appraisal, and I was not ordered to get one. We made the showing that there was nothing in the bank account. We needed to do that title review, and we did that, and that took most of the money. We could not have afforded an appraisal, and an appraisal on land that clearly is not of brand new, high-end condition is not always worth it. But I didn't mislead the court in filing the HERCHAC valuation in any way, shape, or form. I didn't label it an appraisal. I mean, these are the facts in the case, in writing. This is my frustration, is that, I have a whole list of horrible things I'm accused of under Rule 11, and I've never, in 20-plus years, had a Rule 11 violation made against me, but let alone, there's no exhibit showing a court order that I was ordered to get an appraisal. The HERCHAC two-pager that was filed as Exhibit 21, nowhere on it says that it's an appraisal. Nowhere on the inventory says it was done as an appraisal. There is no attempt to mislead this court. There is no attempt to mislead the court on, what was it?
well, Ms. McCann, I've read your responses, and I think that they address these issues quite well. And I recall ordering you to submit a better inventory than the first inventory, which I think maybe was done by Ms. Durkee. I don't remember the timing.
It was done by her 2 months before I came in.
And, I recall ordering you to get and to do an inventory. But in any event, we have a question in the chat from Lori. What is currently in the First National Bank of Orwell estate account?
Nothing. We actually have a letter from the First Bank of Orwell saying that there is no estate account and there was never a Roy Durkee account at their bank. Mr. Durkee never had an account there, and there was never an estate account there.
Okay, so where were the funds that were used? This is my question. Where were the funds kept that were used to pay for the appraisal, not the appraisal, the title search?
Wendy Ann, can you address that?
National Bank of Middlebury.
Is that the only bank you've used, Wendy Ann?
It's my dad's bank, yeah, it's the only one I've used.
Is that the only bank he used?
It's the only bank that he used after the guardianship.
Okay.
Okay, so is there an estate account at the National Bank of Middlebury?
Yes.
And what is the amount that's currently in the estate account at the National Bank of Middlebury?
Less than a couple hundred.
Okay. And Lori poses the question, what bank were the taxes paid from?
National Bank of Middlebury when my husband and I didn't pay them.
Wait,
When your husband and you paid them. Is that what you're saying, Wendy Ann?
My husband and I paid for the first 2 or 3 years after my dad's death, and the last one for calendar year 2023 was paid out of my dad's account at National Bank of Middlebury.
Your dad's account, does he still have his own bank account at the National Bank of Middlebury or Guardian?
No, ma'am, it was turned into an estate account.
So that was actually paid from the estate account at the National Bank of Middlebury, the most.
That's correct.
Payment. Have the 2024 taxes been paid?
They have not.
And when are they due? And I don't know, each time is.
It's around Veterans Day.
So that will be coming up.
correct.
This is going beyond where we are.
Right, this is certainly beyond what we were scheduled to talk about, but it does seem somewhat relevant,
Well, to the accounting, it will be.
so.
I have
To
a
the
letter
extent
on
it
my
will
plate.
be relevant.
So
like-
if we could go back to the, if we could go back to the motion for sanctions.
Well, we're going to hold on that, Ms. McCann, because I want to make sure that Ms. Packard, Lori, has the opportunity, when her mind is clear, to submit anything further that she wants to submit. She has up to 21 days to do that, or to notify the court that she's not going to submit anything. After 21 days, that means, I'm just looking, it's the 28th, so 21 days from now would be the 18th of November. No, it's the, I'm sorry, it's the 29th, would be the 19th of November. If she doesn't submit anything by the 19th of November, the court can make a decision based on the issues in the record. If she does submit something further, then you may respond. Please don't respond beyond your current responses. If she does it, Lori does not file something else. Okay? This, this case has got over 200 filings already in a small estate case, which is certainly not at all helpful in terms of getting to things. Okay, so, and then if I see something in the responses that leads me to believe we need to have a further hearing on the motion for sanctions, I will set it for a hearing. If I don't, I'll just make a decision based on the filings that we have in the record today and going further forward.
Thank you, Your Honor. I hope you can understand my desire to clear my name.
I certainly can. I certainly can.
Thank you. But my time is better spent on accounting. So,
It is. It is much better spent on accounting. Ms. Packard, do you know now whether you intend to submit anything further? I presume that Lori is writing. Lori asked me to look at her statements above, which are that the past due taxes are paid from the First National Bank of Orwell account. I'm not going to go look right now, Lori, to see if that is correct, but in any event, it is irrelevant to the discussion for today. That was just a question that you posed as to what was in the First National Bank account. We've gotten an answer by Ms. DURKEE that there was nothing in those accounts, and that they had a letter from the bank saying so. So I will give you the 21 days so you can respond when your head is clear. I hope you fully recover from your COVID. It certainly is nasty. I last had it in June, and it was not appreciated. It was right at the beginning of my vacation. So, it was not appreciated. And I hope that you will recover fully and soon, Lori, from your COVID. So issue the orders that I have described. So, and I will try to get the orders done today so the court can get them out as soon as it can. And thank you all for being here today. I appreciate everybody's time. I know how valuable people's time is. And I do appreciate Lori doing the best she could under the circumstances to make her questions and testimony known through the chat, even though there's unfortunately no way to preserve the chat as evidence other than what I've read from it. So, thank you all.
Thank you, Judge.
Bye-bye.
Bye.